The Lawsuit Reform Alliance of New York held its annual meeting today in the Capital Region. The theme this year is New Legislative Leadership, New Opportunities. With former Assembly Speaker Sheldon Silver on trial for his involvement with an asbestos cancer law firm, reform advocates are hopeful for changes in the state legislature. So far, change has been slow to come, however. Joining me now to talk more about this is this year's keynote speaker, lawyer and author Philip Howard. He is also the founder of the Coalition Common Good. Thank you so much for being with me.
Nice to be with you.
So you delivered your keynote today.
Yes.
And what was the focus?
The focus was the need for a new political narrative to look at legal reform, not through a narrow lens of let's limit lawsuits, but what do we need to create a structure of law, both lawsuits and justice as well as bureaucratic and regulatory law, that enhances people's freedoms. So how do we make it so that government works better and also without unnecessary burdens on starting a new business or being a teacher in the classroom?
So we've gotten to the point where we're so litigious, and this is a societal thing, writ large, not just New York, although New York has its own set of unique problems, but that people are afraid to act. So your argument is that it's curbing people's ability, their freedom to live effectively as they might, without worrying about, if I do this, am I going to get sued?
Right. It's really a kind of laissez-faire attitude towards lawsuits has resulted in a general practice that that businesses never give job references. Teachers were told never to put an arm around a crying child. People close down ponds and rivers because they're afraid they might get sued if somebody goes for a swim or enjoys them, that sort of thing. It's doctors waste an estimated $100 billion a year in defensive medicine. That's $1,000 for each family in America, just because they don't trust the system of justice.
So what can government do, though? I mean, because there must be some fine line between government infringing too much, right, and putting too many limits on a person's freedom to sue effectively.
Sure. Well, first, a lawsuit is an act of state power. It's a tool of freedom, but not an act of freedom. It's just like indicting someone. You're indicting them for money. If you win, the sheriff will come and take the house away. So it's very important that lawsuits be there to protect against abuse, but it's also important that lawsuits not be overused to take away people's freedoms. And it's the latter part that hasn't happened in the last 40 or 50 years. And so people have gotten very defensive and scared, and it's undermined freedoms and actually undermined the economy more broadly. So what's needed, I believe, is it's actually more responsibility by judges in certain kinds of claims to ask, will this claim impair the reasonable freedoms of people not in the courtroom? So somebody sues because their kid falls off, or a kid falls off a seesaw. Well, the question should be, is that a reasonable risk or not? Because it doesn't matter what a jury does in the lawsuit. It doesn't matter what ultimately happens. If you might get sued, the school and the park district's no longer going to have seesaws.
It's the precedent that gets set.
No, it's not even the precedent. It's the claim. It's the possibility of a claim. It's the fear of a claim. So if you go to playgrounds in New York today, you're not going to find a seesaw, a jungle gym, a climbing rope, a merry-go-round, anything that's fun for a kid over the age of 5. And it's actually materially impaired according to child development experts, the children's physical and mental health.
So that, though, I mean, judges have the ability to do that. You don't need to change the law in order for judges to do that.
Yes, you do.
You do?
Yeah, judges now view their job as, I was debating the McDonald's hot coffee judge years ago, and he said, who am I to judge? And judges have the idea that they're just referees in a neutral process. And increasingly, and there was actually a very important appellate decision case this year by the New York federal court, appellate court, actually citing one of my books, saying in a case where someone was suing because their child got sick while on a trip to China, and the parents sued the school, and he said, well, if you allow schools to be sued because they didn't warn against an obscure illness, then schools are going to stop going on field trips. So we as a court have to actually draw lines of what's a reasonable risk or not Otherwise, we impair everyone's freedom.
So that was a decision that was made in New York.
Yes.
I mean, how does New York stack up in other states when we talk about this problem? I mean, are we overly litigious in New York, and are we able to reform? And I mean, I would argue at the legislative level we are, and there's reasons for that, which we can get into.
Right. Well, in general, New York State has a responsible judiciary, but in the 50 states, they rank pretty much near the bottom when it comes to allowing people to sue for a lot of things and for a lot of money. So New York is a worse place to do business from a litigation standpoint.
So the putting a cap on awards, on jury awards, for example, I mean, this is something that we've had numerous fights about, and we've done, you know, it's difficult to come up against, for example, and the one I can remember most clearly in my mind is children who suffered from brain trauma, for example, right? I mean, it's difficult to come up against that when you see such a sympathetic individual.
Sure, and while I generally think putting limits on lawsuits is important, people ought to know kind of what they can be sued for, you know, when they go through life or they're doing business or whatever. But that's actually not the most important requirement of justice. If a baby's born with cerebral palsy, it's a tragedy. There'll be a lawsuit for $20 million for a lifetime of care for that baby. It really is a tragedy. But the science says that almost nothing a hospital did could have caused that. It's generally caused by a virus in the womb. So we have a system of justice that won't protect the doctors in the hospitals. They end up paying out millions of dollars in those situations. Society ought to take care of that child, but the hospitals shouldn't be liable. And what happens when you have the current system is you get 50% more cesarean sections that are medically indicated, because doctors, in case it's the one in, you know, 1,000 kids who has cerebral palsy, they have a defense say, oh, we didn't have a vaginal birth, and therefore it couldn't have been my fault. Well, that's not healthy for the mother or the babies for all those cesarean sections.
Generally speaking, I mean, now this issue of reform has been really in the news since Sheldon Silver was charged, which was, of course, a number of months ago now. Now he's on trial, and we're watching this all unfold. And it's really sort of a pox on the House of Albany. Albany itself is on trial. But also there's a lot of hope among reformers that because he was such a prominent attorney and because he blocked, allegedly, a lot of reform from coming to the floor, because he was so close to the Trial Lawyers Association, because he himself was an attorney who was making a lot of money from his referrals, that there might be an easing in the legislature, in the assembly specifically, when it comes to making some of these changes. But it seems to me that the structure exists. The trial lawyers remain powerful. I mean, just because Shelley Silver is on trial isn't going to stop the entrenched system against reform.
Right. It's a scandal. And whatever happens in that case, and whatever the facts of the case are, the fact that someone who made huge amounts of money, not practicing law, but referring plaintiffs, and then on the other hand exercises public power to stop legal reforms, should be a scandal. And the way to fight this, in my view, is not to go toe-to-toe with the trial lawyers, but to make the broader point to the public that a litigious society is actually undermining everyone's freedom. It makes it so that schools can't be managed well, and hospitals and businesses. And what we need is not to block lawsuits, but to actually draw the boundaries so people know who can sue for what. That's what law is supposed to do. It's supposed to support people's freedom, not give a legal hatchet to everyone whenever they get disappointed.
But so that's the key, though. I mean, isn't this more also a cultural education and a cultural shift that's necessary? Because we've gotten to the point where we are so litigious that people say, well, I'm entitled, I need to get mine, because they see the person who burned themselves with the extremely hot coffee. And now we have, you know, ridiculous warnings about this beverage that you're about to consume is hot. Be careful, you bought it because you wanted something hot, and now you might burn yourself. And everybody wants their piece.
Right. And so you have this absurd situation where people no longer know what's right and wrong, and we have so many warning labels that they don't do any good, because it's like the boy who cried wolf. It's just a universal thing. So yes, it is cultural, and but leadership starts at the top, And so if you have more judges stand up and say, or even better, although unlikely to happen in New York, a legislature that passes a simple law that says to protect the freedoms of people not in the courtroom, judges shall draw the boundaries of reasonable risk as a matter of law, so people know where they stand. You know, if judges were to do that and would actually say, gee, you know, our seesaw is a reasonable risk, if so, then we can't allow this claim to go forward. Subject to appeal. That would be, you know, that would be ultimately, I think, what's needed here is people need to understand, starting with judges, but also the public, that lawsuits are not a free good. If you let anybody sue for anything, you may like it when you're disappointed, but as you go through the day, you're not allowed to do the things you like to do.
Well, it's a fascinating discussion, Mr. Howard, and I thank you so much for having it with us this evening.
Thanks for having me.